Welcome. I'm Joanna Bond. I'm the Dean of the Law School. I've just started my third year as Dean, and it is my great pleasure to welcome you to the 40th Annual Chief Justice Joseph Weintraub Lecture. We're particularly honored tonight to have the Honorable Barry T. Albin with us tonight to deliver this year's Weintraub Lecture, entitled The Impact of Public Opinion on Judicial Decision-Making and the Uncertain Fate of Individual Rights. I cannot imagine a more timely topic, and I'm grateful that Justice Albin has agreed to be our honored lecturer. In 2002, Governor James McGreevey nominated Justice Albin to the New Jersey Supreme Court. Justice Albin left private practice at the firm of Wilentz, Goldman, and Spitzer and joined the court, where he would serve with distinction for 20 years. During his time on the court, Justice Albin authored over 400 opinions. And after 20 years of public service on the state's highest court, Justice Albin joined the law firm of Lowenstein Sandler as a partner in the litigation group. He is also a past president of the New Jersey Association of Criminal Lawyers. It is a great honor to welcome you here tonight, Justice Albin. As many of you know, this lecture series is named after Chief Justice Joseph Weintraub, who was nominated to the New Jersey Supreme Court in 1956 to fill the vacancy created when Justice William J. Brennan was appointed to the U.S. Supreme Court. Chief Justice Weintraub took seriously his role to modernize the state Supreme Court in significant and lasting ways. I would like to offer a special welcome to our Weintraub alumni, Justice LaVecchia, Judge Karchman, and Judge Sabatino. Thank you for joining us tonight. Finally, it is my pleasure to introduce the president of the Rutgers School of Law Newark Alumni Association, Courtney Johnson. Courtney is a 2015 graduate of the law school, and we are so proud to call her one of our esteemed alumni. In addition to tirelessly serving as president of the Alumni Association, Courtney is an associate in the Government and Regulatory Affairs Group at the Gibbons Law Firm. I want to thank Courtney and the Alumni Association for their continued support of the Weintraub Lecture. And I want to, after the lecture, welcome all of you to join us upstairs on the 4th floor for dinner. Again, thank you for joining us here tonight and for joining us for this inspiring event. Courtney.
Yeah. All right, good evening, everyone. Thank you, Dean Bond, for that lovely introduction. As Dean Bond said, my name is Courtney Johnson, and I am a 2015 law graduate from Rutgers School of Law Newark. I'm also the president of the Rutgers School of Law Newark Alumni Association and a government and regulatory affairs attorney at Gibbons. Thank you all for joining us this evening for the 40th Annual Chief Justice Weintraub Lecture. Welcome to the many esteemed members of the judiciary and dignitaries that have joined us here tonight. I'd like to also welcome and thank Dean Joanna Bond, Rutgers Law faculty, staff, alumni, and friends for being here this evening. We very, very much appreciate you being here. I'd like to also echo Dean Bond's welcome to our Weintraub alumni, Judge Karchman, Judge Sabatino, and Justice LaVecchia. I apologize, my phone is jumping around a bit. Thank you also to Associate Dean Rob Steinbaum, Lizzie Swiderski, Naran Ibrahim, our trustees and co-chairs, Mark McHale and Pat English, and the many others whose labor went into making the lecture this evening a success. The Alumni Association is honored to co-sponsor this signature event with Rutgers School of Law each year. It's one of the premier events for our legal community, and we're so grateful to have you all here. For those of you who are unfamiliar with the Chief Justice Weintraub Lecture, it is named in honor of Chief Justice Joseph Weintraub, as the Dean said, who served as the second Chief Justice of the modern New Jersey Supreme Court after Chief Justice Vanderbilt following the 1947 Constitution. Each year, we gather to hear from one of our foremost legal scholars on an issue of importance to the bar and the public. and this evening will be no different. Chief Justice Weintraub was a son of Cranford, New Jersey, and graduated from Barringer High School right here in Newark. He served as Chief Justice from 1957 to 1973, and the Weintraub Court was known for its impact on modernizing New Jersey and increasing the public's approachability to the court. Chief Justice Weintraub famously stated, "I would not use a multi-syllable word when a four-letter word would do." United States District Court Chief Judge John W. Bissell concurred with that assessment, saying that the Chief Justice favored brief opinions written clearly in language that was readily comprehensible to the lower courts, to the bar, to the parties, and the public. They are pictures of clarity, which most certainly served as a guide and inspiration to his colleagues in crafting opinions assigned to them. I'd like to extend a special welcome to the Honorable Barry Albin, retired Associate Justice of the New Jersey Supreme Court, who we are honored to hear from this evening on the impact of public opinion on judicial decision-making and the uncertain fate of individual rights. Justice Albin is a son of New York, but has served the great state of New Jersey well. Like me, he completed his undergraduate studies on the banks of the Raritan at Rutgers, the State University of New Jersey, and he earned his Juris Doctorate from Cornell Law School. As Dean Bond said, he began his career as Deputy Attorney General in the Division of Criminal Justice in the Appellate Section. The justice also served as an assistant prosecutor in both Passaic and Middlesex counties before he began his association with Willents, where he was named partner in 1986. Justice Albin served on the state's High Court for 20 years. He was nominated by Governor McGreevey in 2002 and sworn in by Chief Justice Ports in October of that year. The Senate reconfirmed Justice Albin for a second term and tenure in 2009, and he retired from the court in July 2022. During his time on the court, Justice Albin authored more than 400 opinions. He was not shy about standing up for citizen civil rights or issues of public importance in those opinions, whether it was a majority opinion or a dissent. Justice Albin is now a partner in the litigation group and the chair of at Lowenstein Sandler and chair of the firm's appellate practice, where he offers a unique perspective during the 40 years of experience in his practice of law as a prosecutor, defense attorney, civil litigator, and as justice of the state's high court. Justice LaVecchia, a Weintraub alumnus, served on the New Jersey Supreme Court with Justice Albin for nearly 20 years. On the occasion of his retirement, she lauded Justice Albin's work ethic as unsurpassed and noted that his careful review, research, and deliberation made each of his colleagues ensure they were equally prepared. In essence, his diligence and preparation ensured that those who appeared before the court and his colleagues on the bench brought their A game. I have no doubt that Justice Albin's careful review, diligence, and preparation means that we are in for a treat during this evening's lecture. So without further ado, please join me in welcoming Justice Barry T. Albin.
First, I want to thank Courtney for reminding me to shut my phone off when her phone was jumping around. I want to thank the Rutgers Alumni Association and Peter English and Mark Mahale for extending this invitation to give the Weintraub lecture. It sounded like a great idea at the time, and until I had to write it. So I want to thank Dean Bond for that very nice introduction. Courtney as well, and everyone who's in attendance here. Members of the Supreme Court, past and present, members of the federal state judiciary, maybe someone from the federal judiciary, I'll cover that just as well, and colleagues from the Lowenstein firm, and distinguished guests and friends. Thank you all for being here this evening. You know, for 20 years, I sat in the Supreme Court conference room, and staring down at me was the face of Chief Justice Weintraub from this magnificent portrait. We were fellow Cornell Law School, Cornell alumni, and I often imagined him saying, "Don't screw up." I think I may have disappointed at times, but I don't think I disappointed myself. The other week, my wife and I, Dina, who's here, we were riding on one of the major highways in New Jersey, and we saw this billboard advertising an attorney. It just had one line, and it was, the justice you deserve. That's all it said, the justice you deserve. I turned to Ian and said, that's exactly what clients don't want. But I'm about to talk about the justice that we do want, and that is really the focus of my remarks. So the subject of my remarks this evening is the impact of public opinion on judicial decision-making and the uncertain fate of individual rights. The great constitutional scholar, Paul Freund, once said that the Supreme Court should never be influenced by the weather of the day, but inevitably will be influenced by the climate of the era. Professor Freund was using weather and climate as metaphors for public opinion. But the truth is, on some of the great constitutional issues challenging individual rights, the United States Supreme Court has been influenced by the weather of the day and by the climate of the era. The Supreme Court is not sheltered from the winds of public opinion. Judges do not operate in some rarefied and idealized world where they are hermetically sealed off from public opinion. Judges live in the real world, a world where cultural values and social customs are constantly changing, a world where they are exposed to the roiling passions and prejudices of the day. Whether consciously or subconsciously, judges are influenced by the spirit of their times and the turbulent events swirling about them. And this is particularly true in wartime, when the drumbeat of patriotism is loudest, and when, as the Roman orator Cicero said, the laws fall silent. But it is also true when progressive movements lead to a public awakening to the injustices caused by socially repressive traditions and invidious discrimination. History teaches us that the preservation and recognition of constitutional rights may depend on a certain critical mass of public support. And when that critical mass of public support disappears, then our courts may become unreliable guarantors of our rights. And when that support is strong, courts will be more inclined to protect and preserve our rights, and also to recognize rights that have been long denied to some oppressed or forsaken class of our citizens. An independent and courageous judiciary is the first line of defense in the preservation of our rights. But ultimately, the survival of our rights may depend on an enlightened, engaged, and vocal citizenry, a citizenry that embraces the values of liberty. I am not presenting a general theory that explains everything, just some lessons that history teaches us. The drafters of the Bill of Rights intended to build a firewall within our national charter to protect minority rights from the will of the majority. The drafters knew that the executive and legislative branch, spurred by an inflamed and misinformed public, might act to silence critics of the government and to curtail fundamental rights of some dissident or marginalized group. If the Constitution is working as intended, the majority should not decide whether a supposed radical can protest a government's war policy, whether a Black child can attend the public school, or whether a gay person can marry. As Benjamin Franklin was leaving the Constitutional Convention on September 17th, 1787, just after the delegates had signed the Constitution, a bystander asked, "Well, doctor, what have we got, a republic or a monarchy?" And he responded, "A republic, if you can keep it." That is still the challenge of our day. The fate of the great American experiment depends on we the people, not just an independent judiciary. The Constitution signed by Dr. Franklin likely would have died stillborn had it not been for the promises made during the ratifying conventions that the first round of amendments would contain a Bill of Rights. It was those rights for which the founders had fought a revolution. The founders were alarmed by two potential extremes: the tyranny of the majority and the rise of an actual tyrant imposing authoritarian rule. Under a Bill of Rights, our fundamental liberties would be insulated from majoritarian rule in the legislature and an overweening exercise of power by the executive. The framers conceived of the Bill of Rights as a check on both. Initially, James Madison expressed skepticism about a Bill of Rights. He feared that they would serve as nothing more than what he called parchment barriers, promises that weren't worth the promises that were made on the paper on which they were written. In a letter to Thomas Jefferson in 1788, Madison wrote that experience proves the inefficacy of a Bill of Rights on those occasions when its control is most needed. Repeated violations of these parchment barriers have been committed by overbearing majorities in every state. Madison expressed his belief that the legislatures, speaking for the majority community, pose the greatest danger of oppressing some weaker party. Thomas Jefferson replied, "If we cannot secure all our rights, let us secure what we can." He added, "The tyranny of the legislatures is the most formidable dread at present, and will be for long years. That of the executive will come in its turn, but it will be in a remote period. Whether we are currently in one of those remote periods, as Jefferson predicted, I will leave to your judgment." The framers viewed the judiciary as transforming the Bill of Rights from parchment barriers into bulwarks of liberty. Alexander Hamilton said in Federalist 78 that an independent judiciary would, I'm quoting him, "guard the Constitution and the rights of individuals from serious oppressions by a majority of the people." But he understood, and I'm quoting, that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it had been instigated by the major voice of the community. Constitutional rights remain majestic principles until they are tested in particular cases. To some degree or another, a judge's view of the Constitution shall be shaped by the temper and spirit of the times. Justice Holmes said that a page of history is worth a volume of logic. So let's look at some history. In 1798, a mere 7 years after the adoption of the Bill of Rights, the Congress in the hands of the Federalists passed the Alien and Sedition Acts, in part in reaction to the seizure of more than 300 American ships by France. The threat of war with France was real, but it was used as a pretext by the Federalists to repress their domestic political opponents, the Democratic Republican Party, led by Thomas Jefferson. This was a hyper-partisan period in American politics, not so different from today. Party-controlled periodicals hurled vicious and ugly verbal broadsides against members of the opposing party. The Sedition Act made it a crime to publish slanderous and malicious writings about the Congress or the president, who at the time was John Adams. The government, armed with the Sedition Act, arrested approximately 25 prominent Democratic Republicans. 10 members of the Democratic Republican Party, including newspaper editors and a congressman, were prosecuted and convicted before partisan Federalist judges. 2 of those partisan judges were Supreme Court justices, Samuel Chase and William Patterson riding circuit. Jefferson described this period as the reign of the witches. The Sedition Act expired in 1801, the same year that Jefferson became president, who upon entering office pardoned all of those convicted under a law that made it a crime to speak freely. Its sister law, the Alien Enemies Act of 1798, a wartime measure, did not expire. It has been invoked, even recently in peacetime, to deport without typical due process rights Venezuelan nationals purported to belong to a violent gang. After America's entry into the First World War in 1917, the administration of Woodrow Wilson ruthlessly suppressed speech criticizing the government's war policy. Those who expressed opposition to the war in ways that would be deemed inoffensive today were prosecuted under the recently enacted Espionage Act that is still invoked today. In 1918, Eugene Debs, who had been the socialist candidate for president 6 years earlier, gave a speech at a rally in Canton, Ohio, publicly voicing support for several of his socialist comrades who had been in prison for their criticism of the war. As a result, Debs was charged with obstructing the recruitment of servicemen into the armed forces. What did Debs say that made him the target of the prosecuting authorities? He spoke to the crowd mainly about his belief in the virtues and ultimate triumph of socialism, which in that day was viewed by many as a threat to the existing capitalist order. He praised his imprisoned socialist comrades. He criticized war in general, and he added this, and I'm quoting him: "It is extremely dangerous to exercise the constitutional right of free speech in a country that is fighting to make democracy safe in the world." For making that speech, Debs was convicted and sentenced to 10 years in prison. That conviction was affirmed by United States Supreme Court Justice Oliver Wendell Holmes, Jr. In 1921, Debs' sentence was commuted by President Warren Harding. Many others were rounded up and prosecuted under the Espionage Act because of their radical beliefs in opposition to the war. And not to be outdone, more than half of the states passed their own sedition laws. Under Montana's sedition law alone, 79 people were convicted and 41 received prison terms. And those of German descent were particularly vulnerable to prosecution. A traveling wine salesman was sentenced to 7 to 20 years for calling wartime food regulations a big joke. In 2006, the governor of Montana posthumously pardoned all those convicted. After the bombing of Pearl Harbor and America's declaration of war in December of 1941, a public wave of hysteria swept the West Coast. The military commander in that region, General DeWitt, recommended the evacuation of the entire Japanese American population on the grounds of military necessity. By February 1942, President Roosevelt issued an executive order that resulted in the removal of approximately 120,000 individuals of Japanese ancestry from their homes in the West Coast and their placement in detention camps. 2/3 of those detained were American citizens. Although the justification for the executive order was military necessity, it was a product of fear, racial prejudice, and misinformation. There were some dissenting voices, including Roosevelt's own Attorney General, Francis Biddle, who later wrote, "The Constitution has not greatly bothered any wartime president." But one of those dissenting voices was not the Attorney General of California, Earl Warren, the later Chief Justice of the United States Supreme Court. He supported the mass displacement and detention of Japanese Americans who resided in his state. In Korematsu versus United States, by a vote of 6-3, the United States Supreme Court upheld the mass detention of Japanese Americans who committed no crime against the United States. Justice Black, who wrote the opinion for the court, acknowledged that most of those detained were, quote, no doubt loyal to the United States. The court's majority, however, refused to reject the findings of the military authorities. One of the dissenters, Justice Murphy, characterized the government's action as a legalization of racism. Most Americans in time would agree with that assessment. More than 80 years later, in Trump versus Hawaii, Chief Justice Roberts wrote, I'm quoting, "Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law or under the Constitution." From the distance of 80 years, it is certainly correct and safe to say that the decision was gravely wrong the day it was decided. But would 9 other justices have decided the case differently? One of the most liberal justices ever to sit on the United States Supreme Court, William O. Douglas, voted with the Korematsu majority. In the late 1940s and early 1950s, during the so-called McCarthy era, a period of anti-communist hysteria, the public was whipped up into a frenzy about the Red Menace. Suspected communists were hounded out of government and blacklisted in private industries, including Hollywood. In this same period, in what would become known as the Lavender Scare, thousands of gay and lesbian federal employees were terminated or forced to resign as security risks on the basis that they would be more susceptible to blackmail by foreign agents because of their sexual orientation. During this time, one eminent jurist expressed his concern that America was entering a new age of witch hunters, intent on informing standards of conformity. In that toxic climate, leaders of the American Communist Party were convicted of violations of the Smith Act, which made it a crime to advocate the overthrow of the American government by force or violence. But the basis of their convictions was action and not speech, the defendants' advocacy of communist doctrines, and it posed no imminent danger to the nation's security. But nevertheless, in 1951, in the midst of the Korean War and the ideological conflict between capitalism and communism, the Supreme Court affirmed the convictions of 11 of the defendants in the case of Dennis versus United States. That decision helped fan an already poisonous atmosphere that had overtaken the country. Justice Black, in dissent, lamented, "Public opinion being what it now is, few will protest the conviction of these communist petitioners. There is hope, however, that in calmer times, when present pressures, passions, and fears subside, this or some later court will restore the First Amendment liberties to the high preferred place where they belong in a free society." Later Supreme Court decisions effectively repudiated the Dennis Court's narrow reading of the First Amendment. Today, we condemn the government's prosecution of dissenters in the early Republic and during the First World War. We condemn the internment of Japanese Americans during the Second World War, and we condemn the witch hunts of the McCarthy era. However, at the time, too few people spoke up. So why did courts fail in their essential task to guard the fundamental rights of vulnerable minorities from the serious oppressions Hamilton warned about in the Federalist Papers? Why did the Bill of Rights become what Madison feared? Parchment barriers. One answer, I believe, is that a critical mass of public support had not formed to protect the targets of repression. And the other is that the fundamental rights are at their greatest peril when there is a real or perceived threat to national security and the public is in the grip of fear. In the midst of a crisis when alarm bells are ringing and perfect knowledge is unattainable, it may become difficult to distinguish between a real threat and an exaggerated or concocted one. Some exaggerations may be a mistake of well-meaning people, and others will be intended by those eager to exploit fear for some cynical purpose. The invocation of the language of war, even in peacetime, is used to galvanize support for an end justifies means approach. Our constitutional rights are the first casualties of war. In the name of war, a war against drugs or crime or narco-terrorists or some other perceived evil, it becomes easier for the government to take expedient measures that do not conform to the Constitution. So why have courts at times failed in the mission that Hamilton conceived for them? The truth is that the communal fever or prejudice that sweeps through every sector of society can also infect the courts. Judges are not Platonic philosophers. Like all of us, they are living through the hurly-burly, turbulent events of their time. Our courts must protect constitutional rights, not just in the best of times, but also in the worst of times, when those rights are at their greatest peril. An enlightened public that believes in the promise of our Constitution will help promote an atmosphere of respect and tolerance in which those rights can thrive. And when there is a critical mass of public support, courts can better navigate the crises that confront them. In contrast to the historical examples I've just mentioned stands the Pentagon Papers case, New York Times versus United States. In 1971, in the midst of the Vietnam War, a war that deeply divided our country, a war that led to protests on college campus and demonstrations throughout the country, the United States government sought an injunction to prevent the New York Times and the Washington Post from publishing a classified study entitled History of U.S. Decision-Making Process on Vietnam Policy. The study revealed that the public had been deceived by its government in its conduct of the war. The Supreme Court held that the government had not met its burden to justify a prior restraint of speech, even though the executive branch claimed that publication threatened national security. In a concurring opinion, Justice Black, the author of the Korematsu opinion, said that, and I'm quoting him, the paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people and sending them off to distant lands to die of foreign fevers and foreign shot and shell. Justice Stewart, in his concurring opinion, said, the only effective restraint upon executive policy and power in the areas of national defense and international affairs may lie in an enlightened citizenry, an informed and critical public opinion, which alone can here protect the values of democratic government. In 1971, in a divided country, there was a critical mass of public support for the publication of the Pentagon Papers. But it is hard to imagine that the court would have allowed a similar publication during the First or Second World Wars, or even during the McCarthy era. Now I want to speak about rights that have long remained dormant, but emerged into the light because of a changed social and cultural landscape that brought into focus the wrongs perpetrated against a minority community. And that those movements are the gay rights movement and the civil rights movement. So in 1954, the United States Supreme Court held in Brown versus Board of Education that state-mandated separate but equal school facilities for whites and blacks violated the 14th Amendment guarantee of equal protection. Today, that decision is taken as an article of faith. Then, however, the decision was a brave and bold step forward in a country still infested with racial prejudice. In deciding Brown, the Supreme Court overruled the 1896 case of Plessy versus Ferguson, which upheld a Louisiana law that mandated segregated railway cars that provided separate but equal accommodations. In support of the outcome, the Supreme Court in Plessy noted that it was universally recognized that state legislatures could establish separate schools for white and black children and forbid the intermarriage of the races. Thus, in 1896, our nation's highest court had sanctified the disparate treatment of blacks under state law. Only Justice John Marshall Harlan dissented, writing, "Our Constitution is colorblind and neither tolerates nor knows differences between classes of people in our country." When Plessy was decided, racial prejudice was deeply embedded in the customs and attitudes of the people in this country. And in many places, state-sponsored racial discrimination was a way of life and cruelly enforced, particularly in the South, under Jim Crow laws. The dissenter, Justice Harlan, who spoke of a colorblind constitution, was the visionary, addressing the future, not a society ready to accept the true meaning of equal protection of the laws. When the Supreme Court overruled Plessy in 1954 and discarded the separate but equal doctrine, it was not just that different justices were sitting on the court, but that those justices confronted a different world. Between the years 1896 and 1954, there developed a more enlightened understanding of race relations, and the agenda for racial justice had progressed through the democratic and legal processes in changing social mores. For one, a determined civil rights movement had come into being. The NAACP Legal Defense Fund, led by Thurgood Marshall, challenged discriminatory laws throughout the South and won victories in the United States Supreme Court, which ordered the integration of the all-white University of Texas Law School and a graduate school program at the University of Oklahoma. During the Second World War, whites and blacks fought and died together on battlefields in the Europe and the Pacific. And later, Harry Truman ordered the integration of the United States Armed Forces. And Jackie Robinson broke the color barrier in professional baseball. Moreover, a tolerant and progressive attitude took hold in northern states. For instance, 7 years before the Brown decision, in 1947, our New Jersey Constitution prohibited racial segregation in public schools. The social and legal advances paved the way for the Brown decision, which, though resented by some in the North and met with determined and sometimes violent resistance in the South, found acceptance in the nation. Yes, it took courageous judges in Brown to render the decision, but a critical mass of public support made that outcome possible. However, the Supreme Court was not ready to correct other racial injustices. In 1955, the court denied a petition for certiorari in a case called Name versus Name, which would have allowed it to invalidate Virginia's criminal statute banning interracial marriages. There, a Virginia couple, a white woman and a Chinese man, were married in North Carolina. When they returned to their home in Virginia, the Virginia Supreme Court ordered their marriage dissolved. The United States Supreme Court declined to review the case. In my view, not because the justices believed that the Virginia law was constitutional, but because they did not believe that the timing was right. The justices feared that invalidating the ban on interracial marriage at that moment might incite violence and impede the enforcement of the integration of public schools in the South. In 1955, despite the Brown decision, not a single Black child attended school with a white child in 8 states in the South. In 1956, 12 Black students matriculated into the all-white Clinton High School in Tennessee. It was the first school to be integrated in Tennessee. 2 years later, white supremacists blew up the high school. In 1957, President Eisenhower sent federal troops into Little Rock, Arkansas, to protect 9 students from violent mobs as they integrated the all-white Central High School. In light of the fraught response to Brown, the court waited for another day when public opinion ripened from undoing an unconstitutional racist custom that was embedded into the marriage laws of the states in the South. Not until 1967, in Loving versus Virginia, did the United States Supreme Court strike down Virginia's ban on interracial marriage, and in the process, similar laws in 16 states. By that point, the cause of civil rights had won acceptance in Congress, in the court of public opinion, and in our courts of justice. Swift-moving changes in public opinion were also at the vanguard of the gay rights movement. In 2015, the United States Supreme Court in Obergefell versus Hodges held in a 5-4 decision that the 14th Amendment's promise of individual liberty guaranteed same-sex couples the right to marry. But consider this: during a good portion of the second half of the 20th century, gays and lesbians were barred from holding many positions in government and from serving in the military. The police targeted them, our immigration laws excluded them, and our society stigmatized them. Indeed, in 1986, less than 30 years before Obergefell, the Supreme Court in Bowers versus Hardwick held that the Constitution conferred no right of primacy to same-sex intimacy and upheld the laws in many states that made same-sex intimacy a crime. What happened in the years between Bowers and Obergefell to bring about such a revolutionary change in the traditional definition of marriage? The language of the 14th Amendment didn't change. The nature of the injustice did not change. Instead, the public's consciousness of the injustice perpetrated against gays changed. For one, a committed gay rights movement took shape in the 1970s. In the next 40 years, popular culture and media advanced a greater awareness of the right of members of the LGBTQ community to live and work as equals in our society. Probably most important of all, people came to realize that members of the LGBTQ community were their children, their brothers and sisters, their friends, their coworkers. During this period, in New Jersey, comprehensive legislative enactments and judicial decisions, step by step, extended equal protections to the LGBTQ community, making it unlawful to discriminate against individuals on account of their sexual orientation. The United States Supreme Court slowly took up the march. In 1986, it struck down an amendment to the Colorado Constitution that conferred an affirmative right to discriminate against persons based upon their sexual orientation. That was an affirmative right that was voted on by the people of Colorado. In 2003, the Supreme Court overturned Bowers. And in 2013, it invalidated the Defense of Marriage Act, which barred federal recognition of same-sex marriages that states had made lawful. Then followed the 2015 Obergefell decision, which guaranteed the right to same-sex marriage. By 2015, the critical mass of public support had been reached. The District of Columbia and 16 states, including New Jersey, had already legalize same-sex marriage. In a perfect system of justice, our rights should not depend on public opinion or the sentiments of the time. Equality should not take generations to achieve. But consider Justice Kennedy's words in Obergefell. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. But let me ask this. Did Blacks not know the nature of the injustice in the 100 years between the passage of the 14th Amendment and the recognition of their rights by judicial decrees and legislation? Did gays and lesbians not know the nature of their persecution in the years before their rights were recognized? It is the majority that supported or tolerated the persecution of Blacks and gays who had to be enlightened, and then for an intrepid judiciary to lead the way. The simple truth is constitutional rights may not be guaranteed unless there is a critical mass of public support for those rights. Courts do not operate in a vacuum. Judges may be swayed by the same prejudices that blind their fellow citizens. The promise of our Constitution depends on an enlightened public. Every successful civil rights movement has educated the public about the nature of the injustice while seeking vindication in our courts. Courts can do much to preserve freedom, but they cannot do it alone. And that is the message that I believe Judge Learned Hand conveyed in remarks that he made to a group of immigrants to whom he administered the oath of citizenship during the Second World War. Hand said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. While it lies there, it needs no constitution, no law, no court to save it." And so I will end with this thought. An intrepid judiciary is essential to the protection and preservation of our rights. And we have an intrepid judiciary in the New Jersey Supreme Court. But our great American experiment still depends on we the people. Thank you. I'm waiting to find out who's going to be giving notice about the food. Got a hungry audience.
Thank you again, Justice Alvin, for that lovely lecture. And as a reminder, you're all invited to join us upstairs for dinner. So we hope to see you, and thank you again for your attendance.